Hello. Today on Subrogation, we're going to talk about the Graves Amendment. I'm Jason Sullivan, and you may be wondering what the Graves Amendment is about. Well, it's a federal law that was passed in 2005 that provides protection to rental car companies and leasing companies for damages that those vehicles cause. It's named for the representative that passed it, and it was passed in 2005. Initially, there were many challenges to this law, questioning its constitutionality. Could the federal government actually regulate this? And as courts have later held, yes, they could. And the reason for this law was that prior to 2005, rental car companies and leasing car companies were being sued for damages caused by their vehicles. Now, they weren't operating the vehicles, they had rented them to somebody, or it was on lease with an individual private person. Those individuals would get into car accidents and cause damage. Those damages then would lead to lawsuits in which those companies were brought in. And they were very expensive, and there were many multi-million-dollar judgments because there were severe and legitimate injuries. However, the argument by the rental car companies and the leasing industry was that these damages were going to put them out of business. It was going to be too expensive for them to get insurance to cover all of these risks. Can you imagine if you just had a vehicle that anybody could drive? You had no way to know their driving history, whether or not they were a good or qualified driver. Rather, they just were willing to pay, so you let them have the vehicle. That's kind of the situation that the rental car companies find themselves in. They can't really control what happens with the vehicle and how it's driven once it leaves the lot. And their argument was the risk that this presents was too expensive. They couldn't get insurance, and when these awards were entered, it put them at risk of going out of business. So in 2005, the Graves Amendment was passed. So let's look at the language of what the statute says. 49 U.S.C. 30106 says, an owner of a motor vehicle that rents or leases the vehicle to a person shall not be liable under the law of any state or political subdivision thereof by reason of being the owner of the vehicle for harm to persons or property that results or arises out of the use, operation, or possession of the vehicle during the period of the rental or lease. If the owner is engaged in the trade or business of renting or leasing motor vehicles and there is no negligence or criminal wrongdoing on the part of the owner. So what exactly does this language mean? Well, first, it covers those that are in the business of renting or leasing vehicles. Now, for our conversation, we'll really just be talking about rental car companies, although a situation can arise where someone is leasing a vehicle from a credit company. However, most of the cases in which you will see a claim where you wish you could pursue the rental car company, it's going to be in the rental car scenario. So it is looking at those that are in the business of it. It is not those that lend their car to a friend, or it's a one-off chance where they let somebody use their vehicle. For protection under the Graves Amendment, they must be in the business of renting or leasing those vehicles. So knowing that that's what it covers, you have to look to see how can we possibly get around the Graves Amendment. So there are a couple ways to look to escape the application of this. And the first is direct liability on that rental car company. If the rental car company has done something wrong itself, it can be found liable. It has to be something different than just owning the vehicle. So the first thing is negligent entrustment. And we will have another session on negligent entrustment that goes into a lot greater detail. But for purposes of this, negligent entrustment is giving the keys to a vehicle to someone who's a dangerous or incompetent driver. A couple of scenarios for this that you might think about come up. First, someone's going on vacation. They're going someplace nice, they're ready to celebrate, so they get to the airport and they have to wait, and they have a few drinks. Then they have a few more drinks while they're on the airplane. And by the time they land, they stumble over to their rental car counter. They ask, hey, can I have my car now? They give them the confirmation number. And the person who's renting the car knows or should know that this person is intoxicated. Now, if they're the only authorized driver on the vehicle, it would be negligence on the company to give the keys to this person who's obviously intoxicated. Another scenario would be if someone didn't have a driver's license. If you ever rent a vehicle, one of the first things they ask you for is a copy of your driver's license, or your driver's license, in fact. And if you don't hand that over, many times they will not rent you the vehicle. And the reason for this is, in some states, failure to have a driver's license could be evidence that you're an incompetent or incapable driver. Now, a lot of states that's not the case, and we'll discuss more in the negligent entrustment session. but it could give rise to a cause of action directly against the rental car company because they knew or should have known someone without a driver's license may not be qualified or a safe and competent driver. The other scenario to think about, and it came from a case in New York, Palacios versus Aris. Someone had come into the country, they were going to rent the vehicle. They handed over a document that they claimed was an Israeli driver's license. Now this document was all in Hebrew, the person at the counter could not read it, and there was no photo on this document. They let the person rent the car, they drive off, and they're in an accident. Now it's discovered that that document was not actually a valid driver's license, and in fact, the person who rented didn't have a valid driver's license. The court in that case said they ruled on a motion for summary judgment, so they didn't rule on the question of what was the actual verdict, but they simply said there is a question of fact, whether or not a rental car company breached any duty by accepting this document that was in a language it couldn't understand and didn't include a photograph, yet it was purported to be a driver's license. Was it negligence for them to accept that document and rent the car to the person? So that is another area to look for along the lines of negligent entrustment. The other area to look for is negligent maintenance. So all rental car companies are going to have a duty to maintain their vehicles. When you go rent the vehicle, you expect that it's in good working order, in safe conditions, that it is safe to operate on the highway, and it will function as it should. Now, if there are reports that brakes are squeaking, or the rental car company fails to take it into routine or scheduled maintenance, and because of that failure, there's an issue with the car that causes a car accident while somebody has it out on the road during a rental, the rental car company may have direct liability for that. Again, it's not liability merely by owning the vehicle, but it's liability for breaching their duty of care, for failing to have that vehicle fixed or repaired or just regularly maintained. Finally, another area for direct liability would be an employee's negligence. If you rent a vehicle and you see them driving them up to the front of the building for you to pick up after you sign all the paperwork, those guys may be driving that same, 800-yard route a dozen times a day. They're very familiar with it. Maybe they're just not paying as much attention. If they were to hit your car or somebody else's car while that happened, while they're in the scope and course of their employment, the employer, the rental car company, could be found liable. So if you do have a case where there's a rental car company involved, always ask yourself, was this on a rental or was this an employee operating it? It may make a big difference between what liability might exist for that rental car company. The next thing that we want to discuss is financial responsibility laws, and this comes up relatively frequently. Section B of the Graves Amendment says, "Nothing in this section supersedes the law of any state or political subdivision thereof. Imposing financial responsibility or insurance standards on the owner of a motor vehicle for the privilege of registering and operating a motor vehicle, or imposing liability on business entities engaged in the trade of business or renting or leasing motor vehicles for failure to meet the financial responsibility or liability insurance requirements under state law." So you may be asking, how do I resolve this? Rental car companies can't be found liable just because they own a vehicle, so why would a state ever be allowed to impose financial responsibility laws? And just as we talked about, there can be direct causes of action for negligent maintenance, negligent entrustment, or negligent operation by an employee. All of these things, it would make sense that a rental car company should have insurance coverage for its own actions. So in those cases, financial responsibility laws can still be imposed at the state level. However, for purposes of subrogation, it's not going to give you a cause of action. Let's say a rental car company doesn't have that financial responsibility. It's not the proximate cause of the loss. A final thing to consider is purchasing insurance at the rental counter. When you go in to rent a car, a lot of times they offer you additional coverages. This coverage, if it's a liability coverage, would cover you for damages you caused to other people while you're renting the vehicle. So, if you ever have a tortfeasor, someone who causes a car accident with your insured, and they're driving a rental car company, try and do the investigation to determine if you can get your hands on a copy of that rental agreement. Did that person purchase the additional liability coverage that was offered at the rental counter? If they did, it doesn't make the rental car company liable for the loss. Rather, it gives you another pocket, that liability policy that was purchased, as a way to recover. hopefully increasing the odds of recovery on a loss. Again, it's not a direct cause of action against the rental car company, but it is an additional source of recovery against that renter. So from a subrogation recovery perspective, if you are dealing with a Graves Amendment, and specifically if a tortfeasor was operating a rental car vehicle, what are the things you should look for? First, look for direct liability. Was there negligent entrustment? Was there negligent maintenance? Or was there negligence by a rental car company employee? Finally, did the renter take out additional liability coverage? Despite the fact that the Graves Amendment abolishes liability for rental car companies, they still can be liable, just not vicariously. So you need to do this investigation to determine whether or not you might find a way out of the Graves Amendment, and then that way you could pursue your claim. If you'd like a copy of this checklist, please email us at video@rathbonegroup.com. Thank you very much for listening to this information on the Graves Amendment. If you have any questions, we welcome you to reach out to us. For On Subrogation, I'm Jason Sullivan, and that's the long and short of it.